Jefferson County Court at Law Number 2 is back in session. The court is in session with its jury trial docket. Next case is clause number M332988. Case is filed the state of Texas versus Lester Mouton. Mr. Mouton, would you please come forward? Mr. Mouton, your full name is Lester Mouton?
Lester Mouton Jr.
Okay, how you doing, Mr. Mouton? Well, I'm doing fine. Thanks for asking, Mr. Mouton. You are represented in your case by your attorney, Joel Vasquez. Attorney Vasquez, how are you doing?
Good, John. How about yourself?
I'm doing fine. And the state is represented in this case, let's see, by attorney Erica Porter or attorney, okay, by attorney Erica Porter. Attorney Porter, how are you doing?
I'm doing great, yeah, thank you.
That's good. Wait for this. Let's see, that's Mouton. Okay. Case back in session. Cause number M332988, case of style state of Texas versus Lester Mouton. Now, Mr. Vasquez, Mr. Mouton's case is on the trial docket. On yesterday, you announced ready. Okay, and I guess the state wants you to come forward, at least come forward on this particular case. What is the reason why we're coming forward?
I think just both council and the state bringing this before the court is not
Okay.
the state bringing it to council.
Okay,
May I speak?
yeah, somebody, yeah.
Thank you, Judge. I would re-urge my motion for a 1-week continuance, even though I know it's untimely. I announced trial yesterday morning, then discovering some additional evidence that Mr. Mouton needs to view before we move on to trial. I filed the motion, I checked with Ms. Porter and then filed a motion for continuance. And I would ask that the court reset us 1 week for trial and leave us on the trial docket. And we'll either work it out next week or ready for trial.
And the state is not opposed to the motion.
Well, we I'm gonna need to find out what our trial docket look like next
And
week.
just, I want to urge to the court, and I'm like, I filed continuances in my case,
Right,
but that also leaves Ms. Porter, and the court knows how long Ms. Porter's been practicing as a prosecutor, and I won't be there to help, and if she will be on her own.
understand.
Therefore, we want the court to understand that her taking trial by herself is pretty soon for the tape by herself without me here, and I have to go get my CLE. I have to
Okay.
practice.
I think when I was a prosecutor, I tried my first case the first week. Had never tried a case before, so it can be done. So
Judge, I've done it.
nobody held my hand. Okay,
We would
she
be
went to,
hurt once again.
and if I'm not mistaken, Ms. Porter has been practicing law for a number of years. I know she practiced as a defense attorney, but now she's practicing as a prosecutor. So,
Whatever you choose to do, I'm fine with.
Okay.
I think we feel more comfortable practicing together.
I understand.
However, whatever you choose to do, we'll defer.
I understand. I mean, people have different practices, but I mean,
Mhm.
I came out of a background where we only had one prosecutor in the court. And, we had to do everything ourselves, so. But, I mean, we still set next week, and now you brought that up. That's interesting that you brought it up because he's asking for a continuous next week. And now you're saying he'll be ready to try the case next week. But now you're saying, well,
Well, but hold on.
she's not here. She's gonna be here by herself.
And first of all, the state told the court, we object to 1 week recess anyways. We don't have time to get witnesses.
No, he asked for a 1 week reset.
Yeah.
Y'all was approaching together on this.
Regarding the reset.
But in regards to that, we
Okay.
stated to the court, we need a month for
All
it.
right.
Okay, anything within a month, we can't get witnesses. It's
Okay,
not-
well, probably should have told him that because he's saying,
He asked, I didn't ask anything about a week.
he's saying he'll be ready in a week.
Well, that's fine. He doesn't have to bring all the witnesses and I'll prove the case.
Okay. But I mean, y'all wouldn't be ready in a week is what you're saying.
So, all I'm saying, standard, we need a month.
I understand that.
So resetting in a week is great for everybody except the state who has got to.
So we wouldn't, I mean, I don't see how that would be practical to reset it a week. If you won't be ready in a week, I didn't say that. Listen to what I'm saying. I said it wouldn't be practical, which means that he's asking for a week. You wouldn't be ready in a week. And so we can't reset it a week because you won't be ready next week because you need at least 30 days to get your witnesses, et cetera. I understand that. So this brings us back to where we're at now. That you saying that you need it reset so that he can look at a video.
Yes, sir.
And it's gonna take him all that time to look at the video.
Well, it's 3 videos.
Okay, are they 1 hour each? What's the length of the videos?
They're about 45 minutes to an hour each.
Okay,
Maybe 45 minutes to an hour, 15.
okay. And so now let me ask you this question again. Are these videos that you just found out about?
I think this I've had them, Judge. I just dropped the ball or fumbled the ball.
Well, I understand that, but now let me do this here. I'm gonna look at this case. Oh, this is a 2022 case. No, but that offense date was 2022. It had to be filed sometime after that. Let's see. Looked like it was filed they only filed it 3 days later. Yeah, August 23rd, 2022 is when it was filed. Oh, let me do this before I get that. That's just a link. What were you reporting it? Okay. So you were appointed in January. No. You were appointed in November 8th of 2022. Okay, let's see how many resets we've had. November, notice of resetting. Notice of resetting. I'll tell you what we'll do is this. Notice of resetting. Oh, back in March, it was reset for, what is the announcement? Oh, please, on it before March. Oh, it was reset to March, okay. And then, I didn't get sending notice. Oh, I see. So we had the Odyssey in March.
Mm.
And then it was reset in February till May. Okay. And then April, May. I guess the other recess is not in here, but May till, maybe May till this month. I tell you what we're gonna do is, I mean, we give you time to let your client, view the tapes. And, I mean, your case is on the jury trial docket. We pick a jury today, we can come back on, Thursday, to put on testimony and give you a day, for you to go over the stuff with your client.
Like this Thursday?
Yes,
Okay.
okay, we'll do that. Okay,
Thank you, Judge.
all right. All right. All right, so you,
We didn't talk about was Peraza's client.
Ms. Farrar, okay, y'all can have a seat.
Thank you.
I just turned the plea paperwork in on.
Okay. I'll sign it. That one's been was, we're signing up.
Okay, you signing a BNY, and it's my understanding there's an issue with the Cody.
Well, we've got
Mr. Cody.
we've got an agreement to resolve that, Judge. It's just.
Oh, you have
giving her
agreement?
time,
Okay,
giving
so
her-
you have an agreement, Mr. Cody, once you come forward?
And we're not gonna do any plea today, which
Right,
we're setting for a plea.
okay. Now, there's a issue with the charging instrument.
We're gonna file, what we're gonna do is refile, basically refile,
Amend?
but that also do amend, but that also gives her the time which we agreed to give her anyway. So it's okay.
Extra time.
Extra time to get her a short.
Okay, so y'all got an agreement worked out
Just
regarding some jail time. She needs some time to get her affairs in order.
Correct.
And while she's getting affairs in order, y'all gonna amend the information, and then we'll come back in on a date certain to dispose of the case.
Yes, sir.
Correct.
Okay.
That's why we're not pleading it today. And
Okay, I understand. So we do have an agreement worked out.
we do
Yes, sir.
Okay, so how much time does she need?
whenever 30 days, it doesn't,
30 days?
just a step forward.
Give us 30 days? No, it's gonna be, we're gonna move it on the plea docket?
Plea trial,
We're not gonna,
The
whatever
plea doc.
announcement. Doctor.
yeah,
Be a plea.
we'll put it on the plea docket. She need 30 days. And that's. What's,
Because
yeah, the Cody.
Yes.
Okay, Mr. Cody. Which is cause number M331726. Your case is going to be reset.
Do we know what day?
She's gonna give us a date. October the what? 13th. She's gonna check her calendar. What day of the week is that? Okay,
That sounds good.
October 13th. Okay, this case is gonna be reset to October 13th. 2023, Mr. Cody. Mr. Cody, your attorney's gonna get your reset. You're gonna get a copy of reset from your attorney. Once you get a copy of reset, you'll be free to go.
And
And
that
you
will
have
be at 9. Correct.
9 a.m.
Okay.
Yeah. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you, Judge.
Okay, and then now we got Benoit. Oh, what about Walker?
I think we're gonna do a bench trial now.
We're gonna do a bench trial on
We're
Walker?
gonna call a name.
Okay. But you
And
know,
I was told the rest of Rife went away.
that guy, yes, he, yesterday, remember, that's the guy. Let me do this here.
Richie had a
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M331604. Case is style of State of Texas versus Jared Christopher I. Walker. Mr. Walker, is that your full name? How are you doing, Mr. Walker? I'm doing fine. Thanks for asking. Mr. Walker, you're representing your case by your attorney, Attorney James Padgett. Attorney Padgett, how are you doing?
Bless your honor, thank you.
And the state is represented in this case by Attorney Kobe Hoffbauer. Attorney Hoffbauer, how are you doing?
Good job.
State, are you ready?
Ready.
Defense, are you ready?
Ready, your honor.
Okay. At this time, state, would you please read the information?
Yes, Your Honor. Cause number 331.
Well, let me do that before I get any further.
Okay.
Now, Mr. Padgett, you and your client were scheduled for a jury trial today, is that correct?
Yes, your honor.
However, you all are waiving your right to have a jury trial,
Yes, your honor, we're waiving our right to a jury trial.
and the state is joining in that waiver, is that
We are,
correct?
Your Honor.
Okay,
Yes, sir.
Mr. Hoffbauer, you may go forward.
Cause number M331604, State of Texas versus Jared Christopher I. Walker. In the name by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Jared Christopher I. Walker, hereinafter styled the defendant heretofore on or about January 5th, 2022, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Narasha Ariana Williams, hereinafter styled the complainant by punching the complainant about the face and body. And at the time of said assault, complainant was a person with whom the defendant has had a dating relationship against the peace and dignity of the state, signed by the Assistant Criminal District Attorney.
Mr. Walker, how do you plead? Not guilty? Okay. State, would you like to make an opening statement?
No, we're right to.
Defense?
We'll waive, your honor.
Okay. State, you may call your first witness.
State calls Narasha Ariana Williams.
Narasha Williams. Narasha Williams. No response, Your Honor.
Your Honor, for the record, the state has tried multiple times to contact Ms. Williams prior to the date. She did take the options class and was to set up a meeting with us. That never occurred. We played phone tag, I believe, but we spoke to Ms. Williams today, not 5 minutes ago, and she said she was not coming, was not to come for this trial and participate in the prosecution. Therefore, the state rests, Your Honor.
Okay. Defense?
We would move for an instructed verdict, your honor.
That motion will be granted. Mr. Walker, you've been acquitted of these charges. Your attorney is going to get a copy of the judgment of acquittal. Once you get a copy from your attorney, you'll be free to go and you have a blessed day.
Thank you.
Okay.
Can I get the word excuse to put in the work?
I'm gonna tell you where to go.
Yeah.
It's right next door. I'm gonna walk you over. Thank you, man. Excuse you.
Yeah, he got a copy.
Where you going? Man, take that. I appreciate it.
You need to send it back to
Where you going?
All right.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M329308. Case is styled the state of Texas versus Ashley Ann Benoit. Ms. Benoit, is that your full name? Ms. Benoit, would you please raise your right hand? Ms. Benoit, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Benoit, you may put your hand down. How are you doing, Ms. Benoit? You doing good? That's good. I'm doing fine. Thanks for asking. Ms. Benoit, you're represented in your case by your attorney Laura Peraza. Attorney Peraza, how are you doing?
I do, Your Honor, thank you.
Now, Ms. Peraza, do you waive a record in Ms. Benoit's case?
I do, Your Honor.
State is represented in this case by Attorney Colbert Hoffbauer. Attorney Hoffbauer, how are you doing?
Good job.
That's good. Now, Ms. Benoit, did I swear you in already? Okay, now, Ms. Benoit, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ashley Ann Benoit, on or about January 1st of 2021, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Benoit, do you understand what you've been charged with? And to this charge, Ms. Benoit, how do you plead? Guilty, not guilty, or no contest?
No, sir.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Benoit, I have before me a document. Okay, I'm gonna have to,
Oh, did I leave something out?
yeah. You gotta check that box. You can erase that. It's the DWI class.
Oh, yes. Sorry. Okay.
All right, thank you. Ms. Benoit, I have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? Ms. Benoit, you notice there's one box that's checked. That box is DWI first. The range of punishment for a Class B DWI first is minimum 72 hours to a maximum 180 days in the Jefferson County Jail. A fine that does not exceed $4,000, or you could be given both such fine and confinement. Do you understand the range of punishment for a Class B DWI? Okay. Now, on page 2 of the same document, there are 2 sets of initials. The first set of initials. Okay, there's 1 set of initials. The initials are on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document? On page 3 of the same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that is titled Trial Court Certification, the defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes.
Ms. Benoit, before you sign and initial these documents that I just showed you, did your attorney, Ms. Peraza, go over these documents with you? And did you read and understand everything that Ms. Peraza went over? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Benoit, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit 2, the probable cause affidavit, which is in the court's file. State, would you like to offer State's Exhibits 1 and 2 into evidence?
Yes, sir.
No objection.
No objection. State's Exhibits 1 and 2 are admitted into evidence. Ms. Peraza, you've advised and counseled Ms. Benoit, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Benoit, your attorney, Ms. Peraza, has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation? Ms. Benoit, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, sir.
And what is that agreement?
In exchange for plea of guilty or no contest, state's agreed to recommend 1 year deferred adjudication and community supervision, a $500 fine, Your Honor, 40 hours community-based service, standard terms and conditions for DWI, also an interlock device due to the fact that it's deferred adjudication, community supervision, all of the standard terms and conditions.
That's correct.
Okay, now, Ms. Benoit, let me do this. State is offering 1 year deferred adjudicated probation. On that, while you're on deferred adjudicated probation, you'll be, well, let me do this before I get into that. Now, Ms. Benoit, do you have a regular driver's license or do you have a commercial driver's license? Regular. And let's see, and the blood alcohol concentration was less than 0.15.
Yes.
That's correct. And this occurred after September 1 of 2019.
Yes.
Okay, so now Ms. Benoit, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $407. You'll also be required to pay a probation fee of $60 each month, your analysis fee $15 each month. You'll be required to pay a reimbursement fee of $15, and you'll be required to reimburse Jefferson County court-appointed attorney's fees of $250. The total amount that you will be required to pay while you are on probation is $188 a month. Will you be able to pay the $188 each month? Okay. Now, you'll also be required to pay a DWI education initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, you'll also be required to perform 40 hours of community service. You'll be required to install an interlock device on any vehicle that you want to operate. You'll be required to complete a DWI education class and an intervention program. You'll be required to complete a DWI education class, and you'll be required to have a drug and alcohol assessment. And you will also be required to adhere to the other standard terms and conditions of your probation. Ms. Benoit, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? Do you accept the state's offer? Now, Ms. Benoit, if you successfully complete this probation, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because she is quite competent in those matters. And you're going to stand next to your attorney, follow the directions of our clerk. Once you finish following the directions of the clerk, you'll be free to go, and you have a blessed day.
Thank you, Judge.
You're welcome. And you're free to go as well, Ms. Barraza, and you have a blessed day. Ms. Hold on.
All the way to the. Where that white sheet is for the name.
But I did, I thought I didn't give it back.
No, it's in the back.
Huh?
It's in the back.
Oh, you thought,
Yeah. Hold on. Yeah. Here. I think.
Where the white,
Now on this thing.
or don't see the white. Yes. Number 15, that would be.
yeah. Well, that one up.
Wherever it is, we want to be. Wherever it is, we want to be. Where my favorite bag.
Well, get rid of that. You need to get rid of it, put that on the.
What?
On the computer, just tell it to come in here. Oh, there she is. Put that on the. Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been called for jury service today in County Court at Law number 2. You will be examined for inclusion on a jury trial hearing a criminal case. Our courtroom hours are normally from 9 to 5 p.m. However, in this court, at 9 o'clock, we usually have a large docket, and our dockets usually go past 12, sometimes to 1 or 2 o'clock. And so in that case, what we normally do is have our regular dockets in the morning, and then our jury docket, we have it at 1:30. And so, our court hours will be normally at 1:30. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected, unless otherwise, you will be permitted to separate for recess, for meals, and at night. Now, I must administer to you the first of 2 oaths. And so I need each one of you to raise your right hand. And once I finish administering the oath, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? Okay, you may put your hand down. Now, ladies and gentlemen, the law requires that each of you must possess certain qualifications to be considered as a juror for jury service. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury trial. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried, and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way that I'm going to ask the questions, I'm going to ask the questions in a group. I'll ask a question. I want you to just answer it to yourself. And then once I finish asking the last question, then I will ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law based on the way you answered the one or more of the questions, just simply raise your right hand, and then I will ask that you will come up before the bench so that we can discuss the matter more privately. And when I use the term more privately, what I'm talking about is we'll turn off the mics, and then we'll put on this device. And we'll put on that device so nobody on the panel will be able to hear what we are discussing. Now, the first question that I'm going to ask that you need to answer to yourself is as follows. Except for failure to register, are you a qualified voter in this county and this state under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question that I have to ask is a question that I'm required to ask by law. We're not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was my last question. Now, is there anyone disqualified under the law? If you think that you may be disqualified under the law, just please raise your right hand. Okay, we have one person. Okay, we have one person. Let's see. That's juror number 17, Lisa K. Tran. Is that correct? Ms. Tran, would you please come forward? Now we'll move on to excuses. If any of you feel that there is an excuse that you would like to claim, after I finish asking the next group of questions in the same manner that I asked the previous group of questions, I would then make the statement, is there anyone here who feels as though that they would like to claim, actually, we're gonna do exemptions. We will ask whether or not anybody here would like to claim an exemption. And so I will, as I mentioned earlier, I will ask the questions in a group. And then at the end, I will see if anyone would like to claim any one of the exemptions. Now, you may claim the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, then you could just continue to be seated. First question, are you over 70 years of age? And I think the law has just changed this year. They've changed the law to 75. So are you 75 years of age or older? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the Senate, House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in this county during the 3-year period prior to today? Are you the primary caretaker of a person who is invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed away from your home location and out of Jefferson County, your county of residence? If any of these applies to you and you would like to claim an exemption, just please raise your right hand. Okay, we have one. Okay. At this time, we're going to have Mr. John, is that Pirtle? Pirtle? Mr. Pirtle, would you please come forward? I'm going to stand over here, Mr. Pirtle. Now we move to excuses. And the way we're going to handle the excuses are as follows. I'm going to read off some excuses that you may claim. And once I finish making the statements, if anybody think they would like to claim an excuse, we would ask that if any of you feel as though there's a reason why you cannot sit as a juror today, we're going to ask that you will come up before the bench so that we can hear your excuse. A juror may be excused for observance of a religious holiday upon the completion of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A person may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel that will be claiming an excuse? If you're claiming an excuse, please raise your right hand. Let the record reflect that no one is claiming an excuse. One person claimed an exemption and one person was disqualified. And now let the record reflect that the remaining members of this panel is qualified. Let the record reflect that the court is in session and cause number M332988. The case is styled the state of Texas versus Lester Mouton. The defendant is Mr. Lester Mouton, who is sitting next to his attorney, Attorney Joel Vasquez.
Good afternoon.
The state is represented by Assistant District Attorneys, Attorney Erica Porter, who's sitting first chair, and Attorney Colbert Hoffmeyer, who is sitting second chair. The court reporter is Miss Ada Christie. She will be taking down everything that is being said, so speak up when you are answering or asking questions. The bailiff in our case is Deputy Woodle. The defendant, Mr. Lester Mouton, stand charged with the Class A misdemeanor offense of assault, family violence. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are only trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer to answer certain questions outside the presence of the other panel, just please say so, and I will ask that you would come up before the bench so that we can discuss the matter more privately. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
McDonald's ready, Your Honor.
Okay. Ms. Porter, the panel is yours. You have 30 minutes, and I will be taking time.
Thank you.
You are.
Good afternoon, everyone. My name is Erica Porter, and I work for the Jefferson County DA's office, along with my partner, Cody Hoffmeyer, and we're representing the interests of you, the citizens of Jefferson County. Our boss is Keith Giblin. He is the DA, District Attorney of Jefferson County. So I'm gonna be moving away from this panel some. You might see me get in front of you here and there, but I want you just to pay attention to the PowerPoint. There's some good information. I'm gonna be referring to the PowerPoint throughout this presentation, okay? You already know what the subject matter of this case is going to be. Assault, family violence, okay, of a household member. Now, we have to prove the state that the defendant on or about on a certain date in Jefferson County, Texas, did intentionally, knowingly, or recklessly cause bodily injury to the complainant. And the defendant and the complainant were family or household members. And we're going to expound upon the definition of what a family and a household member is. Family member. Now, when I say family member, what am I talking about? I'm talking about anybody who is related within third degree of consanguinity, affinity, or including a former spouse. So anybody that you were married to, even if you divorced them, that's still considered your family member. Household member. If you live together, a lot of people don't get married these days. If they just live together, cohabitated, that qualifies as well as a family member. Dating relationship. What if you were just dating that person? Somebody you were just loosely dating, or you were involved in a romantic relationship, family member. Okay. We're having some technical difficulties. What would you expect to see in an assault family violence case in order to determine that person is guilty? I'm gonna start calling on you guys. The more you talk, the better it is for you. So I'll have something to pull from. If you don't talk, I'm gonna consider you just a mute and you're a good candidate for my jury. So I want y'all to get loose enough to get talking to me. I'm gonna just start pointing to you and asking individual questions if nobody volunteers. Okay, so what would you like to see to determine whether a person is guilty or not? Any givers? Anybody want to answer that before I start calling on someone individually? Okay, that's fine. I'll call on William. Hey, tell me, what would you need to see in a case like this?
Some type of physical evidence,
Physical house. What do you mean by physical? Just expound.
those recordings.
Okay. Okay. Very good. What about you, John? Or sons?
Yeah, evidence, any type of videotape, potential witnesses, somebody that saw it, maybe.
Okay, so witnesses, eyewitnesses, you want that person to have been there to have seen the actual occurrence,
If that's possible.
if possible. Okay, so if not,
I could rely on testimony of the victim.
okay. All right, and what about, let's see, Miss Jury Casey? Okay, what about you? What would you like to see in order to convict someone of assault family violence? What would you need to see?
Well, I think that, photos or eyewitness testimony would be good. Also, you could have hospital records if they the hospital.
Okay, hospital records, are they necessary? Do you feel like hospital records are necessary in every case for assault family violence?
You can't have everything in every case.
Absolutely. Okay, so what about you, Mr. William? Hey, no, some my players said, so Philip, what about you, Mr. Philip?
That's pretty much all the above, but I mean, a witness would be a good thing, but somebody would be unbiased, I guess.
Somebody,
Not
so,
close to the person that got hurt that way.
okay, so maybe it's a
Sure.
bystander, someone that saw it that wasn't related or anything. Okay. Did you agree with what Mr. Philip? The minutes? Okay. Anything else you want to add to it?
Just, like I said, witness or maybe whoever was hurt testify.
Okay. All right, so photos, I believe somebody mentioned photos. Oh, you mentioned photos. Okay, so photos made my list. You're absolutely right. Photos are good. You might not have photos in every situation though, correct? So, but photos are good. Let's go. 911. Do you think 911 call is necessary? And I believe you're Tad Walker. What about you?
Yeah, in the timeline, when the cops got there.
So you would prefer to hear a 911 call, but Does it happen in every situation? What about in-court video? If there was a police officer that had an in-court video and it picked up statements, would you want to see that? Okay. And why would you think that would be good, Alexis?
Shows the, whoever the victim is, like, what they're doing, what they look like, time, what their traumatic response is, that you know what that person is.
Would you agree?
Yes.
And your name is Rosa. All right, so what about body cameras? Are you familiar with body cameras, what they are? Okay, and do you think that they would pick up on anything that you would like to see?
Yes.
Testimony, who would you like to speak on in a case like this? Victim, anybody else? I wouldn't say anybody else. The defense. If you want the defense. Yes. All right, and what about you, Ms. Sally?
Definitely, you know, the officers that were there, that are people that were first responders that were there, that were able to see the attitudes and you know, the people that were there, because when you first get there, somebody's, you know, how they're acting is very important.
Okay, so who would agree with that? First responders are someone that could probably be the first people to respond and see the victim. Y'all would want to hear from that individual. Everybody wants to see his eye. You know, we took out some labs, okay, so, and then Law and Order, watch that as well, right? So you can pull from that, those TV shows to think about what you would want to see, right? And you probably use some of those TV shows to come up with some answers today, right? That's great. All right, so if supported by evidence, how comfortable are you? There's no visible injuries. Are you able to convict? Very comfortable, uncomfortable, somewhat comfortable, or comfortable. All right, and who have I called on? Mr. Douglas King?
I can't say I feel any way about those things. We take it into account if it supports the fact that we're convinced of an assault. And I'm very interested in hearing that. Whether or not I think you can have an assault without having a physical injury. Visible. So. I'm sure that in the fact that-
Okay. Okay, and Mr. Timothy? So how do you feel about no visible injuries?
I think it's possible to assault in my physical injury. Depends on the situation and the place.
Okay, so bodily injury is basically a fancy word for pain, so there must be some form of pain, but it doesn't have to be serious bodily injury in this case. Okay, so bodily injury, but doesn't mean you have to go to the hospital or have medical records or anything supporting that, but it does need to be some form of pain. Now, is it easy to come forward about domestic violence? Or do you think it's easy, Ms. Thomas? Why not? Why is it not easy?
Because there's a closeness between the victim and the defendant. That's all.
Okay, and explain that closely.
Usually if it's a family member, there's love involved. If it's a spouse or a partner, there's definitely love involved. So they don't always come forward when somebody.
Okay.
Horrible.
What about you? Do you think it's easy to come forward?
There too, I might be afraid of repercussions
And what repercussions do you think could happen?
from the person that saw.
What do you expect a victim of assault, family violence to look like? What do you expect that person to look like? And I'm gonna get random because I've already called on everyone. David?
There's no telling, I mean, you could be male, female, I mean, really, there's no second thing to look like, I wouldn't say.
Do you have something, I believe you want to chime in and tell me, Ms. Rosa, I think I have. No, Alexis. I'm missing some. jury cases. What do you think? What do you think a victim is supposed
Oh. A victim could look like anybody. Any age.
Does it have to be a child or an adult, or in this case, it's a romantic relationship, so you assume it's gonna be an adult. But it could be a female or male, right?
Yes.
How should they behave? How should a victim behave?
They all behave differently.
So give me an example of what you would think a victim of assault and violence, how they would behave. You think they would be nervous, scared, just
Definitely.
family violence? Raise your hand if anyone you know has been a victim of family violence. We're gonna start with this. So, who's been a victim of family violence? And you are. Sally. Your brother. Oh. He's a victim.
He would, yes,
What happened?
he was the one that was charged.
Oh, sure.
Yeah, he was the one who was charged, and it was, determined that, he had been falsely charged, by his ex-wife. And, they were able to determine the pattern. She had done it to her previous ex-husband, and, it was just, it was getting confusion. And so, but, you know,
So how does it make you feel now towards victims coming out and saying that they were victims of assault?
well, everybody, you know, if you need to come forward, but I know it's hard, and, but, you know, anybody can, you know, make, if with anything, you can have good and bad. So, but yeah, they still, you know, you still need to, you know, they still need to come forward, you know, and, you know, they can find it themselves to come forward.
Ms. Bradley, what about you? You were a victim? You were a victim. And did you press charges again? Did you call police out and you had a trial and everything was resolved through the judicial system? Oh. And you're okay now, and you're able to sit in this trial. Anybody else? I believe I saw one hand.
My uncle, he was beaten up several times by his wife.
Was beating up by his wife.
And she was using my home with her two very young boys, and she was on parties, like she would have herself, or she would have friends of hers.
So how did that make you feel?
I was very young, so I didn't even know very much.
You didn't
My
really
mom.
know it. Look at the wall right there, so red. You see that? I wonder what it's for.
Anybody else?
Oh, that's like she had, okay.
Anybody else in victim of assault and violence? Okay. So there's a cycle, typically. And sometimes it's not the first time that a person is a victim that they report. If they go back, a lot of times they do go back. What should we do about it? Family violence, what should we do? Can we simply round up everybody and punish them all? Can we do that? Why can't we do that? Anybody? Why can't we do that, Mr. John?
It's not all recorded,
Mhm.
so if you don't know about it, you can't do anything about it.
And we must do it on a case by case basis, right? Because everybody has to trial, and investigate and listen to both sides before we move forward. Okay. Think we're not that far. Hiding the phone. What types of things do you hear from family violence victims about their abuse or injuries? What do you typically hear? You've heard stories. Tell me what stories that you've heard from, if you know, a family member or a friend that has been a victim of abuse. What have they told you? Anybody? Okay.
because the person was having a bad day.
What's happening? Making excuses for them. Anybody else?
Most of them will never do it.
One time, one and done. Okay. Do victims lie to protect their abusers? Sometimes they lie to protect their abusers. Why do you think they lie to protect their abusers? They would.
They still love them, I guess. And I want to see them. A little bit crazy as it sounds.
Mhm.
And who knows the relationship that they make work.
Why don't you just do that, you think?
Economically.
Economic. Okay. All right, so there are different sides of stories. Is it possible for a person to have two different explanations depending on when they are given? One story at the time of the incident and another story a little bit later. Sometimes people's stories change. Why do you think that's the case? Why do people's stories change? Absolutely, had a chance to be compressed.
It's the process.
Credibility. What is the victim of family violence thinking when he or she picks up the phone to call 911? What do you think's going on through her head or his head?
Scary.
Okay. Long-term effects of getting the police involved, do you think it goes through their head too? Oh. What's gonna happen if I get the police involved? What is the victim of family violence thinking weeks or months later when a case goes to court? You think that things are processing during that time? Think their mind starts to shift a little bit? Which story most likely is the truth? Which story do you think is most likely?
Probably right.
And why is that? Why do you think that's?
It's happening.
Anybody else have any input on that? You think that the story that's told immediately is probably the truth? Okay.
You're on.
Oh, did I fix some, oh, some consistency. Consistency. Okay, it's fine, tell me.
Well, like you said, they're gonna, the stories can kind of change, you can kind of, your like emotion, and then, things can kind of change, both sides, but if things stay consistent, then it's, more than likely, it's, probably what happened.
Examples of why a complaining witness might not want to prosecute. Tell me why would a complaint, we kind of went through this already, some reasons why they wouldn't want to prosecute. Give me one example of why a complaining witness, why you think someone wouldn't want to prosecute. I don't think you talked in a while.
Not just the defendant, but what the other family members would think about talking about that, because they love them too.
Sure.
They have a relationship.
Maybe not to experience the background from the family. All right. Did you convict the person if you believe they were guilty beyond a reasonable doubt, even if the complaining witness does not want to go forward? Well, complaining witness changed his mind, would you still be able to convict the person? Would y'all still be able to base on evidence? Would you still be able to convict the person? Okay. Who wouldn't? We have a problem.
I have a problem with that.
Okay, that's David. Why? You think you need to complain with?
Well, if they're not willing to testify, then, I mean, even if you have evidence, why wouldn't they? I mean, if they were hurt, if they were injured, if they were abused, and,
You talking about the victim?
yeah.
Well, I think I would convict either way because it's more than about the defendant, it's about the community and having someone out there who does this sort of thing.
Okay. Anybody else have an opinion on that? The victim decides to testify, we just gonna be able to do that.
Well, the facts are already out there, the evidence is already out there.
Anybody can discuss, like Mr. Scott, David saw that they can't. They're not comfortable. That is the one thing.
Yeah, I would be reluctant to,
You would be reluctant. You would need to hear from the complainant.
wonder why they would.
All right. So burdens approved. We have the burden approved. The state has a high burden. Prove beyond reasonable doubt, right? Doesn't mean all doubt, but it does mean beyond all reasonable doubt, okay? And the defense doesn't have to do anything. They don't have to say anything. He doesn't have to testify. The burden proves on the state. Okay. So you'll know it when you see it. Texas doesn't give a definition for beyond all reasonable doubt. Whatever. It's kind of like pieces to the puzzle. Every piece might be, a few pieces might be missing, but mostly all the pieces are there. And you'll know what the puzzle is. All you need is common sense. We're gonna talk a little bit about your prior criminal jury service. There's some of you have served criminal and state juries. Let's talk to Mrs. Bradley. Tell me, you served on a criminal jury?
Yes.
Did you reach your verdict?
Yes.
Okay. You assess punishment as well?
Yes.
Timothy Winkoff, you served on a criminal jury,
Yes,
and you guys reached the verdict as well?
yes,
Okay. And y'all assess punishment?
the last one that,
Okay. Oh, you served on multiple.
served on one in Austin way back years ago, I don't remember who determined the punishment. I think this would be the guy I wanted, but recently, what out there.
Okay. Okay. And I believe Jace, you served on a criminal trial. You assessed, y'all reached the verdict, assess punishment too? Ms. Piper, you served on a criminal trial as well. Okay, and did you come to a verdict? You did. And y'all assess punishment? Okay. All right. I think so. Back to my missing pieces. Can everybody see what that is? What's that piece, a picture of? What's that? Okay. You know, there's a few pieces missing, right? But you can make out what it is. You'll know it when you see it. All you need is, again, common sense. So will anyone on this panel require me to remove all that? Raise your hand if you would. Oh, no, I want Ms. Porter. She has to remove every single bit of doubt in my mind before I convict anyone. Anybody feel like that? No?
In a good case.
Need a good case, definitely, but would anybody require me to remove every single bit of doubt?
Maybe reasonable doubt. It's,
Reasonable doubt. Reasonable doubt, but not every,
reasonable's kind of a,
right, it is, but however, you'll know it when you see it. Don't like the phone, you'll know it when you see it. So would you require me to remove every bit of doubt? Or just make sure that I meet my burden of reasonable doubt?
so you pretty much have to prove it all the way, because that piece that was missing might have been a lock on that trigger. You know, and that was the case.
Okay. Will anyone hold us to a higher burden than beyond a reasonable doubt? So all the way is a higher burden. My burden is what? Beyond a reasonable doubt. Would anybody hold me to a burden higher than that? No. Anybody over here? Anyone who cannot sit in judgment, now's the time to raise your hand. feel like, oh no, I can't judge in a criminal case. I just can't do that. It goes against my conscience. Is everyone here to be able to sit in judgment?
You have 5 more minutes.
Your duty, decide the facts, apply the facts to the law, and follow the law. Can everyone guarantee me that you're gonna do that? Without problems? Okay. Thank you. Any questions for me? All right, thank you.
Mr. Vasquez?
Now,
Back with yours.
Have we voted on?
Yes. You may proceed, Mr. Vasquez.
Thank you. Okay, who wants to talk? Because it ain't gonna be just me for 30 minutes. I can tell you that. Somebody wants to hold forth. Who wants out of here? You do. Everybody do. Do you want out of here, Mr. Salad? No, you're already here. It's hot outside. And you're supposed to. Someone, I think it was Miss Valentine, did I say your name correctly? You said you wanted to hear from the defense. Is that true? How would it help?
Well, I mean, there's always two sides.
Sure.
And, you know, they have as much right to state their side and. I mean, their attitude may be, you know, and their, you know, what they have to say, you know, it's kind of hard, you know, I don't like assuming things. I don't like, you know, making, you know, trying to figure out what somebody, you know, is thinking or doing, or what, you know, what their mindset was. And, you know, they may be innocent, they may be guilty, and, you know, if they don't speak, it's kind of hard to, you know what their part is.
Who agrees with this? Excuse me. Who agrees with this calendar? A lot of you. You understand that this is a state, this paper. Everybody knows that. This is the defendant, the state. State brought the charge to prove the elements of a crime beyond a reasonable doubt. Everybody's lived beyond that, right? You with me, Ms. Glover? Okay. If the court instructs you and tells you, listen, the defense is under no obligation to bring you any evidence, The state started this. They filed the indictment, or they filed the information. It's their burden to prove beyond a reasonable doubt. Not he probably did it, maybe he did it, we're pretty sure he did it. But beyond a reasonable doubt, there's 6 of you. And he's not guilty. And you follow that, even though you're curious, it's human nature to be curious, you wanna hear what everybody says. And I'm sure on the TV shows, the defense testifies a lot of the time. But in real life, I might not say a word, I might not cross-examine one witness. That may be boring, but that's law. Does anybody disagree with that? Is anybody gonna hold it against the defense if he doesn't say a word? I mean, can't fall asleep at the table, but if I don't have any questions and I just don't have any questions, I can't make them up. I used to be bad about that. Everybody okay? You're not gonna hold it against Mr. McDonough?
If he goes to show convincing,
I'm sorry?
if they put on a pretty good convincing argument, I would think that you're gonna try to do the same to show he's not guilty.
I'm sorry, say it again.
If they put on if they have a pretty convincing argument that, you know, he's guilty, I don't think you guys are gonna do the same thing to prove them wrong or show that he is not guilty.
Right? But if it's a strategic decision, it's a strategy in a trial that I don't have any witnesses. I don't want Mr. Ruthon to, I mean, I don't know right now where they go. But if it's my decision for him not to testify, are you gonna assume he's guilty?
And on the other side,
Say it again.
what evidence they put on the table.
Say it again.
I guess it depends on what evidence they put on the table.
When they're through with their case, state rests. And when that case is done and their witnesses are done, their portion is concluded. If you don't think they're proving their case beyond a reasonable doubt, are you gonna require anything of the defense? Are you gonna want to hear from the defense anyway?
They didn't prove beyond reasonable doubt, no.
When would you want to hear from the defense? Mr. Donovan, the same correctly?
Don't make me up. Again, if they don't. Well, if they put on a pretty good case, I guess, yes, I think we want to get from your side.
What if the judge has instructed you though, with the jury charge that the defense doesn't have to testify, doesn't have to bring one, doesn't have to prove anything? Can you apply that law? Can you follow that law? Or are you still going to hear that?
I don't think so, but I keep in that position.
If it's okay, we might call you up and speak in private with the judge. Who agrees with Mr. Donovan? You're still going to expect something from the defense, even if the case hasn't been proven by the state. Anyone else? Mr. Parsons?
I would not. If they've not proved their case beyond reasonable doubt, they haven't met their burden. In which case you don't have to say anything.
Hey, what do you think?
I agree. I'd be wondering why he wouldn't want to defend himself. I'm sorry, even if they put on a lousy case, I'd want to stand up and say, hey, I didn't do this.
Well, he's gonna say that when the information is right at the beginning of the trial. He has to say it then. But his Fifth Amendment right not to be called a defense. Are you gonna hold that against him?
No, I wouldn't hold it against me, but it weigh in the decision. I can't lie about that.
So you would expect him to testify.
I would expect somebody to testify. I'm sorry, I need carried away.
No, but I appreciate you speaking up. There's no getting carried away in here. You gotta speak up. What do you think, Ms. Stacy? You're gonna expect the defense to put on witnesses and for the defendant to testify no matter what?
Well, like they said, they have the burden of proof. That's your choice. To put on the defense or not put on the defense. The
Thank you.
burden of proof is on them.
What do you think, Mr. Walker?
Sometimes nothing speaks volumes sometimes, so it's up to them to.
What do you think? I'm sorry, I didn't mean to cut you off. Sure.
Yeah.
Now, what do you think? Do you expect the defense to testify or to bring any facts?
Here, side. He doesn't want to. We can make him, we cannot make him do it.
Well, what if he's not required to by law? He didn't bring the charge, he's not required to bring the facts that something didn't happen. Are you gonna hold that against him? Ms. Bradley, what do you think?
It's on the state to have reason, to bring the case. It's not on the defense to have a rebuttal. So I don't expect him to say anything.
Ms. Calavera? You've had time to think about it, now what do you think?
It is obviously, I mean, ultimately it is their, it's up to them to prove it. And, he has the right to, speak or not speak. And so, sometimes, obviously, you're the attorney and if it's kind of if it's a close thing, and you feel that him talking would help, weigh that decision in your favor, that's your decision. But ultimately it's up to them, so.
So if Mr. Mouton does not testify, or there are no defense witnesses, you won't hold up, that won't weigh in your decision.
It's up to them. I mean, they have to prove it, so.
Mr. King, what do you think?
I'm going to listen to the evidence that's presented on either side. And that's where I'll make my decision. The burden of proof is here. They have to prove it happened. I'm not really interested in hearing someone prove it didn't happen. They have to prove it did happen. That's what I'm going to do.
The white group, did I say it correctly?
Yes, you did. Good job.
I got lucky, I couldn't do it twice on that.
Actually, he made a statement, he said, I'm not guilty, otherwise we wouldn't be here. All he's required to say by law. Guilty or not guilty, and he's not guilty, so. We're gonna give the man the benefit of the doubt.
He is presumed innocent unless proven guilty. Porter, because of the comments you made earlier, Ms. Porter, about the case you discussed involving family violence. In that case, can you put that aside and judge this case on its merits?
I was very little. I know about it, but I don't know further details.
You just heard about it. And what about you, Ms. President? And what about you, Ms. Collins? Ms. Parsons. The grand jury served. When?
During COVID,
Oh, recently? What was that like?
it was interesting. But they weren't paneling juries at the time, I figured they were going to cancel it, they didn't.
How long is that a year or 6 months or?
Actually, it wasn't all that long. It was actually a special grand jury that was impaneled, looking at it. Indicting a public official in Jefferson County.
Oh my God. Hey, how are you? Good. Who shops at Lowe's? Who shops at Home Depot? Well, don't go to those places anymore. Go see Mr. Pate at Parker Lumber, Gulfway Drive and Port Arthur, Texas. He will sell you what you need, and he will not sell you what you don't need. He doesn't remember me, but that is his reputation. Mr. Domi, you have a son-in-law that's a detective?
Port Arthur detective.
Is any of that going to influence you in this case?
No, I mean, he's not on the, he's not one of the witnesses or arresting officers, so no.
What if he were one? I said, what if he were one?
I'd say I don't be good in that position.
You say that a lot. I'm gonna start doing that. I don't want to be put in that position. And your missus used to work for the U.S. Attorney's Office?
Paralegal.
Someone else in here works for the U.S. Attorney. I forget it. I'm not ignoring Ms. Piper or Mr. Stansberry, but I don't think we're gonna reach it. I think you're out of our strike zone. A bunch of good questions from Mr. Moe, but he didn't join us today. Ms. Casey, you grew up in Nederland?
Yes, sir.
Ms. Butler, which Walgreens did you used to work in? 366?
Down Street, it's down the street.
I think Ms. Porter asked you earlier, Ms. Bradley, what kind of case was it you were on in your criminal trial experience?
Drug case.
At the drug court? And you said that did you come to a finding?
We said not guilty.
Thank you. Hey. What did you do at the Texas Department of Criminal Justice?
I supervise the patient liaison program for the health services division.
Of course, says right here. The reading thing. You said it better than I can read it. Camden, Arkansas.
South Central.
Mr. Winfrey. Did I say right that time?
One, two.
One for two. What does a boat captain do?
He drives a boat,
What body of water?
Nature's River, and big,
That little bitty river? I said, that little bitty tiny river?
river. We do public tours every Saturday.
How long? How long is it going?
2 hours.
Oh. What if you six everything shows, six different birds, six different birds of food. Find that Mr. Bouton is who the state says he is. How would you have to find it? What would the verdict have to be? When I say he is who they say he is, they prove their case beyond a reasonable doubt, all the evidence. What would your finding be? Mr. Walker? What if they don't prove? What if you don't think he did? And what if you don't know or can't decide? You think something happened that you're just, I don't like this case, I don't like hearing about it, something's going on, but we didn't really prove it.
If they didn't prove it, then it's still enough.
Does everybody agree with Mr. Walker? Mr. Parsons, do you agree?
I do.
Okay. Sedona? So. Ms. Casey? What? About it, Brandon? So. Kane? Mr. Winfrey? Piper? Stanford? Well, I'm going to bring this forward and thanking all of you very much. So the way this really works is, we don't pick a jury, you deselect, and each side has 3 strikes and Judge Holmes court. And the first 6 of you that are left are for the jury. But thank you all very much for being here.
Ladies and gentlemen of the panel, we're going to ask that you follow the bailiff out into the hallway, and some of you may be called back in for additional questions. So at this time, we're going to ask everyone to please stand as the panel exit the jury room or the courtroom.